Hello everyone, good evening, welcome to Chandu Biology Classes. So, let us continue our discussion on fundamental rights. In the previous class, we learned introduction to fundamental rights and the importance of fundamental rights. What was the debate when it comes to fundamental rights among the members of the Constituent Assembly, and we also discussed certain very important fundamental rights, that is first three rights, that is right to equality, right to freedom and also right against exploitation. Okay, but before that we also discussed what is Article 12. Article 12 in the previous class also I told you, that is it talks about the state, and Article 13 talks about judicial review implicitly, not directly, but it is talking about judicial review implicitly. What does it say? The parliament can make laws or parliament can legislate on any matter except that it should not violate or infringe upon the fundamental rights. Okay, that means what? It is talking about judicial review implicitly, that is indirectly. The word judicial review is nowhere mentioned in the Indian Constitution. Also, judicial review what? We borrowed it from US Constitution. All these things we studied. Okay, now today we have to discuss on what? We have to discuss on right to freedom of religion and also cultural and educational rights, and also we have to discuss right to constitutional remedies. But before that, let us revise some of the things which we learned in the previous class. So I told you, as per Dr. B.R. Ambedkar, what? Fundamental rights is the most discussed or most criticized part of the Indian Constitution, right? And also he also told that Article 32 is the heart and soul of the Indian Constitution. Why he said like that? We will understand in today's class. Okay, and when it comes to fundamental rights, it is applicable to both Indians and also for foreigners. But certain fundamental rights is available only to citizens but not to foreigners. What are the fundamental rights that are not available to foreigners? That is Article 15, which talks about prohibition of discrimination. Article 16 is talks about what? Prohibition of discrimination in terms of public employment. Okay, Article 19, okay, that is freedom of right to freedom. Okay, and Article 29, and also which article? 30. Article 30. Okay, so 15, 16, 19, 29 and 30. These are the articles which are not available for foreigners. It is available only for Indians. Okay, today we will also discuss, suppose there is national emergency. What are the fundamental rights that are suspended and those fundamental rights which are never suspended? Okay, all these things we will learn in today's session. Also, I discuss Article 14 to 18, that is right to equality. We have different subject matter. Article 14 is talking about right, equality before law and equal protection of the law. Let us revise everything. And prohibition of discrimination on grounds of only of religion, race, caste, sex or place of birth is spoken in Article 15. 16 in terms of public employment. Article 17 prohibition of untouchability, and also 18 abolition of title. Only you can keep titles of military and also academic. And also Article 19 is talking about what? Freedom of what? Right to freedom, and it is talking about production of 6 fundamental rights, 6 rights. That is what it is: right to freedom of thought, belief and expression. Okay, that is it is talking about 6 rights. 6 rights. It is talking about 6 rights. That is, what are those rights? First is you have to go and talk, that is right to freedom of speech and expression. Because of that people will assemble. Then because of assembly you will form association. Then you move and you reside in some place. If you reside, you need some money, that is occupation. Like this you remember the what? First 6 rights, that is production of 6 rights. Next, Article 20 talks about what? Conviction, production in terms of conviction of offences. Conviction means what? Once you are arrested, once you are given a punishment or whatever, at that time you have some protection. What are those protections that you have to understand? One is there should be no ex post facto legislation. No ex post facto legislation means what? Suppose I am arrested today, that is today is May 20. Suppose a law is made on May 25th. For my crime, the law should be applicable from May 20 or before, not on May 25th law. Okay, the law which is made in future, that law should be not applicable. Okay, that law should be not applicable. But certain times certain laws will be made retrospective. That law should also be not applicable. Retrospective means, suppose today I am making a law, but this law will be made applicable from past 6 months. That is the meaning of retrospective, from behind date. Okay, that should not be the case is what they are telling. Okay, for today's crime, whatever the law is there, that should be applicable from today and previous. But if the law is made in future, that should not be applicable to me. As per that, punishment should not be given to me. That is the meaning of no ex post facto. Post means after. Post facto legislation means law. Okay. Next is no double jeopardy. For the same crime, I should not be given 2 punishments. That is, double punishment should not be given. No self-incrimination. I should not be a evidence in my own case. I cannot go and say that I only made it, so please punish me. I cannot say. The court will not accept. Okay, just because I say it won't accept, it needs evidences. Clear? That is the meaning of no self-incrimination. And Article 21 we spoke about right to life and personal liberty. And Article 21A it talks about right to free and compulsory education from 6 to 14 years. From 6 to 14 years of age. And also Article 22 it talks about protection from arbitrary arrest and detention. And detention I spoke about two types of detention. One is preventive detention and also punitive detention. Okay, but right to equality you have to remember one case, that is Indira Savani case. It is about reservation. When it comes to right to freedom you have to remember one case, that is Maneka Gandhi case. It talks about right to life. Okay, and right to privacy is also included under Article 21 itself. Right to health, right to clean environment. Next we spoke about right against exploitation, that is Article 23 is talking about production or prohibition of human trafficking and also forced labor, that is beggar. And Article 24 is talking about child labor. That's it. Now let us discuss about Article 25 to 28, then 29 to 30, then 31 and 32. And I also told you in the beginning itself, in the Constitution, fundamental rights were there in the beginning itself, in the original Constitution itself. But there were how many fundamental rights? There were 7 fundamental rights. But the 7 fundamental rights, that is right to property, was removed from the Part 3 of the Constitution and it was made legal right under Article 300A. When it was removed through 44th Constitutional Amendment Act that was taking place in 1978. It took place in 1978. Now we have how many fundamental rights? 6 fundamental rights. Okay, this one also you have to remember. So now let us continue. Article 25 to 28. Article 25 to 28. So this is talking about right to freedom of religion. Article 25 to 28. So what does each of the article we have to understand? No need to by heart them. One thing you must understand, when you study Indian polity, no need to by heart the articles. You have to understand the essence of the article. What each article is saying, you have to understand in your own words or in your own understanding. You have to know this. Don't have to by heart. Okay. No, because you are not writing the exam. That is, it is not a subjective exam. You have to go and write. Okay. So you have to understand what each article says. So Article 25 says what? Freedom of conscience and to freedom to freely profess, practice and propagate religion. That is freedom of conscience. Conscience means what? Our inner feeling or whatever. Okay, freedom of conscience, I can feel whatever I want, and also freely profess, practice and propagate. Profess means what? I can believe in any religion. Okay, I can believe in any religion and also I can practice that religion. Each religion has its own set of practices. Okay, as its own set of practices, you can practice that. Okay, people will go to temple, people will go to mosque, okay, people will go to church or people will go to Gurdwara, something like that. It is up to them. And propagate means I can definitely go and talk about my religion. I can definitely have the right to propagate my religion. That is, I can go and talk about my religion. But at the same time, I cannot go and what? Preach. I can go and preach, but I cannot go and force people to convert to my religion. See, one thing you must understand, conversion is allowed. There is nowhere in the Constitution which says that there should be no conversion. Conversion is allowed, but forced conversion is not allowed. Okay, don't get confused. Conversion, I want to convert means that is my wish. I can convert to any religion of my choice. Okay, that is allowed, but forced conversion is not allowed. Okay, propagate means you talk about your religion, that is fine. But at the same time, while propagating your religion, don't talk ill about another religion. Okay, that if you do, you are violating other person's fundamental right. So you will be filed a case. Okay, understood? This is what Article 25 says. That means you can practice your own religion. That is what Article 25 says. Now, Article 26. So, freedom to manage religious affair. Religious affair means there can be religious affair means while maintaining how to maintain my temple, how to conduct our festivals. That I have the freedom to do it. Okay, I have the freedom to do it. That doesn't mean that you will do in such a way that will affect the public. You shouldn't do that. Okay, suppose you are holding a profession or not profession, procession, everything. Suppose you are going on the road, you have to hold a procession. Okay, at that time what you should do? You should take the permission of the police. Otherwise, it will affect the public. Okay, that time initially only police will inform in this road procession will go on. Okay, that time police will be or people will be aware. That is the meaning of freedom to manage religious affair. Like I told you, fundamental rights are not absolute. There are reasonable restrictions. Even on right to freedom of religion, there are reasonable restrictions. You can practice your religion, at the same time don't affect others. Okay, Article 26 is talking about what? Religious affairs. Religious affairs. Next, Article 27. No compulsion to pay taxes for religious promotion. No compulsion to pay taxes for religious promotion. Actually, they will come to your home or whatever. They will say, please give this much for our religious this thing that thing, okay, but actually we give it, okay, but there is no rule that you have to give, nobody can force you to give, okay, but actually so many festivals come, they will come to each area, they will come, you must be knowing those festivals and all, they will come, please give money, okay, that type of, this is not possible, that is constitution doesn't allow. Or just because I am being in this religion, they cannot say that you are in this religion so you have to pay this tax, no, they cannot do that. Willingly I can give it as charity or donation, okay, but they cannot say I am entering some temple, you are entering this temple, you have to pay this much money, they cannot say that, okay, they cannot say that, clear? That is the meaning of no compulsion to pay taxes. So 25 is you can practice any religion, similarly 26 is you can manage your religious affairs, 27 is you need not pay any tax for being in some religion, okay, and also 28 freedom from attending religious instruction is state funded educational institutions. That is what, suppose in any state funded institutions, there are various types of institutions. One is private institution, that is completely private, okay, such institutions, suppose it is managed by some religious community, okay, suppose it is managed by some religious community, that time you definitely have to, if you have joined that school, if they are giving religious instruction, you have to follow. But if it is a state government institution or central government institution or state aided, that is the government is funding that institution, in that institution if some religious activity is going on or some puja or some festival or whatever is going on, okay, at that time you cannot force other religious people or any other religious people to come and attend that, okay, it is their wish, if they want they will attend, otherwise it is left to them. So that is the meaning of freedom from attending religious instruction in state funded educational institution. State funded means where government is funding or completely government institutions, clear? Suppose you are studying in a madrasa, okay, there Islamic instructions will be given, there definitely you are compelled to attend because you have chosen to go there, there you cannot say I can't listen, okay, but if you are going to some other institution, suppose state funded institution or some other university, there if they are doing, they have the right to do it, they can do, but they cannot force you to attend, it is your wish, got it? Next example, for example, you must have seen that national anthem, when it comes to national anthem, okay, it is being played in the theaters before the cinema, okay, there was one case, okay, one person didn't stand during the national anthem or whatever, or at that time people hit him, at that time regarding that case itself Supreme Court said you cannot force someone to obey that, okay, it is not mandatory that you have to stand up. After that it changed the decision or whatever, okay, regarding national anthem itself it is the, this is the meaning, okay, this is the kind of scenario that we have regarding national anthem. Only when it is this way, how can you force someone to attend religious instruction, it is left to them, understood? So next thing is limitations, but one thing you must understand when it comes to national anthem, national emblem, national flag or whatever, it is a fundamental duty to respect that, it is a fundamental duty to respect that. Next, coming to limitations, subject to public order, morality, health and other fundamental rights, that is I told you right to freedom of religion or any other right, they have what, they are not absolute, that means there are certain reasonable restrictions. What are those restrictions? Public order. Public order means what? Public order means there should be no disorder, that should be, there should be harmony in the public, okay, suppose you are moving outside in the society, there should be harmony among different religious community or different caste groups, okay, different caste groups, there should be harmony. Just because of one festival it should not affect other people, that is the meaning of there should be public order. And morality, that is it should be as per the morals of everyone, that is good for everyone. Next is health, suppose COVID outbreak was there, that time you cannot go and say this religion is there, this religious procession is there, I have to take part, allow us to take part. By doing that what will happen? You are spreading the infection, that is the meaning of health, that is one of the reasonable restriction. Other fundamental rights, you cannot affect other people's fundamental rights, other fundamental rights, like you are conducting a procession and you are affecting the life of others. Suppose you are conducting the procession, you are taking swords and going like this as a part of your religious belief or whatever, that will affect the other people's life, okay, you cannot violate that, got it? That is the meaning of, that is the meaning of this one, subject to public order, morality, health and other fundamental rights. They can ask a question on this line, very important, what are the reasonable restrictions that are there for right to freedom of religion? One is public order, morality, health, this you remember, public order, morality, health. But as a overall for fundamental rights, what are all the reasonable restrictions? Public order is there, morality is there, health is there, security of the nation, unity and integrity of the nation. unity and integrity of the nation. This much you have to remember, 5 points. Clear? That's all about right to freedom of religion. Right to freedom of religion, this much, 25 to 28. Now let us see cultural and educational rights. Cultural and educational rights, okay, article 29 to 30. Okay, you might ask me a question. Already you told article 21, it is talking about education. Again, why education is coming here? Because we are talking mainly about with respect to minorities. Okay, when it comes to minorities, what are the type of education that you can provide? Okay, what are the type of education that you can provide, or how they can manage their own institutions? Okay, so see here, when it comes to article 29, protection of interest of minorities, that is cultural interest and also educational interest. Okay, protection of interest of minorities. Article 29 is talking about what? Protection of interest of minorities. What type of interest? That is cultural interest and also educational interest. That is their culture should be preserved. Okay, just because they are in less number, you cannot say that you will destroy them and you will eliminate them. No, you have to respect their culture. No matter how small the group is, you have to respect their culture. Okay, there is one concept called, you might have learned in ecology and environment, there is one when you study national biosphere reserves, there is one concept called sacred groves. Sacred groves, you must have learned. That is mainly a cultural entity. That is mainly a cultural, not an environmental entity. That is mainly a cultural entity. Those people also preserve the culture around them, also preserve the environment around them. Okay, so that is the meaning of protection of interests of minorities, cultural and educational. That is what kind of interest? Cultural interest and also educational interest. Next is article 30, right of minority to establish and administer educational institutions. That is right of the minorities to establish and administer educational institution. Suppose you are a minority, you can have your own minority educational institution. Okay, that is also possible in the Indian constitution. That is, you can see lot of Christian run schools are there. Okay, you can see lot of it. Okay, and they are maintained really well, and also you can see lot of madrasas being held. Okay, that is also held really well as per their wish. Okay, they have different rules. For them, they have the rights of the minorities to establish and administer educational institutions. Even for Jains, the monks, they have their own set of institutions. Okay, for them to support the minority itself, separate fund the government is giving. Okay, but if you are already a minority, if you are getting the benefits, you cannot avail benefits under other fundamental rights. That is, you are getting the benefit as a minority, again you cannot ask for reservation again. As a minority you are getting the reservation, again you cannot ask reservation under other under other condition. Got it? So that is the meaning of rights of the minority to establish and administer educational institutions. Among this, one important case you have to remember under cultural and educational rights, you have to remember one important case, that is TMI Pai Foundation versus State of Karnataka 2002, rights of the minority institutions was upheld. That is TMI Pai Foundation is a minority institution. Okay, against this some state government of Karnataka tried to intervene and tried to violate their fundamental rights. So they went to Supreme Court. What happened is Supreme Court supported or upheld the case in favor of this minority institution and right of the minority was upheld. That is TMI Pai, actually this person is a person from Mangalore. Okay, TMI Pai circle is only there in Mangalore. Okay, TMI Pai circle is there. Okay, TMI Pai Foundation, it is an educational institution, it is a minority institution against whom the state of Karnataka intervened and violated their fundamental rights. So they went to Supreme Court. Supreme Court upheld the case in the favor of TMI Pai. So rights of the minority was upheld. Okay, so when it comes to cultural and educational rights, so rights of the minority was upheld, or if they give TMI Pai case is related to what? It is related to rights of the minority. This much you have to remember. Okay, TMI Pai case is related to what? Rights of the minority, or rights of the minority, which of the following is related, or cultural and educational rights, which of the following cases is related to that? The answer is TMI Pai. TMI Pai. Okay, clear? So this is about cultural and educational rights. So 29 is talking about interest of minorities in terms of what? Education and culture, not job. Education and culture. It is not talking about employment. Be careful. And 30 is talking about you can manage your own institution when it comes to minorities. That's it. Next we will talk about article 31. Article 31 I have not written because we have removed that article through 44th Amendment Act 1978. So article 31 was talking about right to property. Article 31 was talking about right to property through 44th Amendment Act 1978. It was put under article 300A. Now it is called what? Right to property is now a legal right. Very important. Question has been asked multiple times. Okay, it is a legal right. It is a legal right. Got it? It is a legal right. It is a legal right. Now, one of the question that they have been asked, and there is an answer that is very tricky, is right to vote. Right to vote is which right? Legal right or constitutional right? Right to vote. Right to vote is not in the fundamental rights. Legal right. One thing you must understand, right to vote is not in the fundamental rights. Right to vote is not a fundamental right, and it is in article 23, 25, 326 I am mentioning again. So, now tell me, right to vote is legal right or constitutional right? See, right to vote is not a fundamental right, it is not a legal right, but it is mentioned in article 325 and article 326. So, right to vote, it is a constitutional right. Right to vote is a constitutional right. Right to vote is a constitutional right. Understood? Clear? And also, right to marry, is it a fundamental right? Right to marry, is it a fundamental? It's not a joke. It has come in the exam. Right to marry is not a fundamental right. It is just a constitutional or legal right. It is not a fundamental right. You have to remember. It comes under right to life. It's right to life. To live, you don't have to marry, no. So it doesn't come under fundamental right. That much you remember. But most important thing is, right to vote is a constitutional right. This much you remember. Please remember, they can ask this question. This has been asked in various exams. So if they want to set the paper, they will ask, they will look at various other papers. They can pick the question and give you. That's why I am telling this. Okay, clear? Next thing. So we will discuss about right to constitutional remedies. But before that, I want to discuss the importance of right to constitutional remedies at article 32. So, Sir Dr. B.R. Ambedkar, what did he say? Fundamental rights is the most important or most criticized part of the Indian Constitution. When it comes to fundamental rights, article 32 is the highest important. Okay, and he told it is the heart and soul of the Indian Constitution. Heart and soul of the, not just the fundamental rights, heart and soul of the Indian Constitution. So you must understand that if there is no fundamental rights, there is no validity for Indian Constitution. If there is no article 32, there is no validity for fundamental rights. So if there is no article 32, you can understand that there is no validity for Indian Constitution itself, because article 32 is the heart and soul of the Indian Constitution. So what do you mean by that? So if there is no article 32, there is no meaning for fundamental rights. So if there is no fundamental rights, means there is no meaning for Constitution itself. So that is the importance of article 32. He gave highest priority. Dr. B.R. Ambedkar gave highest priority to part 3 of the Indian Constitution. Within part 3, he gave highest priority to which one? Article 32. Okay, that is right to constitutional remedies. Under article 32, what are all the things that are there, we will discuss. Okay, right to constitutional remedies, definitely one question will come. Article 32 is what? Right to constitutional remedies. It is called the heart and soul of the Indian Constitution. Clear? Now, let us see what is article 32. So, like I told, it is heart and soul of the Indian Constitution, told by Dr. B.R. Ambedkar. Now, right to approach the Supreme Court for enforcement of fundamental rights, provides rights for enforcement. I told you, suppose, I told you example yesterday, parents are there, you are there and teacher is there. So, if you are not treated well in the school, parents will come, that is the judiciary will come into what? Picture. So, how it comes? It is through article 32. That is, I told you, while discussing the preamble, I told you preamble is non-justifiable. That is, you cannot approach the court. But when it comes to fundamental rights, you can approach the court. Suppose my fundamental right is violated. I can approach the Supreme Court. That means I have the right to move to the Supreme Court to enforce my fundamental right. To enforce what? My fundamental right. That is through what? Under article 32. This article gives me that power. Okay, if this article is not there, there is no meaning for fundamental rights. Because state will come and violate your fundamental right, you cannot do anything. But under this article, I can stop the state from treating me indifferently or violating my fundamental right. Clear? So that is why article 32 is important. This article empowers what? Empowers us to go to the Supreme Court under article 32 and High Court under article 226 to what? Enforce the fundamental right, so that there is no violation of our fundamental right. Okay. So how does it enforce? Suppose my fundamental right is violated. Okay. Suppose my right to move. I want to move from this state to that state, okay, another state, but I am forbidden from it, that is, they are not allowing me, okay, normal case I am telling. So that time I can write a petition, that time the Supreme Court or High Court will take it up. That time what it will do is, it will issue writs, writs means nothing but what? It will issue writs, provides writs, writs means it is nothing but written document, or you can write it as written notice. It will issue, it means it will issue notice against the person who has stopped me from going. against the person who has stopped me from going, allow me to go, the Supreme Court will issue the writs. That is the meaning of written notice. Not just verbally it says, it says in written. Okay, suppose a police has stopped means it can send to the police the written notice. That is the meaning of writs. So like this, there are various writs. You have to understand the name, understand just the meaning of them. Okay, they will give it in the form of match the following also, this one, these writs. You have to understand the name and understand the meaning of it. So let us see what are the writs. So first thing is, the court can issue various special orders known as writs. Okay, first one is habeas corpus. You must have seen in so many movies, habeas corpus. Suppose the police want to interrogate a person or they want to torture a person. When they will arrest is, they will arrest on Fridays. Fridays evening they will arrest. Why? Because Saturday court will be holiday. Okay, Sunday court will be holiday. Till Monday they will get 2 days time. Otherwise, if they arrest any person within 24 hours of the arrest, they have to provide them or produce them before the magistrate. They have to produce them before the judge or the magistrate. That is the meaning of habeas corpus. That is habeas corpus, the meaning itself is produce the body. It means produce the body. The court orders the arrested person should be presented before it. It can also order the set free and arrested person if the manner or grounds of arrest are not lawfully or satisfactory. So understand one thing, habeas corpus, it is talking about produce the body. Habeas corpus means it can be issued against public person also or private person also or public authority also. So what do you mean by that? I told 3 words, public person, public authority or private person. Public person means what? Any government official. Any government official, or you can take it as police officer. He is also a public person because he is under what? He is under government. Okay, that is the meaning of public person. Public authority. Public authority means some institution has arrested me. Suppose CBI has arrested me. Okay, that is what public authority. What do you mean by private person? Private person means some person who is not under the government but he has taken you somewhere. That is, suppose you can understand like kidnapping you. You can understand like kidnapping you. That is against your wish. That is done against your wish. If it is done against your wish, that is nothing but what? That is detention. That is illegal detention. That is illegal detention. Correct? No? Taking you and confining you in some place. Okay. Even that case, habeas corpus can be issued. So understand one thing. Habeas corpus can be issued against public authority also, private also. Public authority also, private also. Understood? So habeas corpus can be issued against public authority also, private also. Now, suppose the police has arrested you. Okay, at that time, within 24 hours, you should be produced before the magistrate. If it is not, he will issue the habeas corpus. That means it is habeas corpus meaning what? Produce the body. Body means it is not a dead body, it produce that person. Okay, that is the meaning. Clear? And it can also say, habeas corpus also includes, it says, release that person. If the grounds of arrest is not constitutional, if the grounds of arrest is not lawful, or if it is not satisfactory, if it is an arbitrary arrest, there are no grounds for arrest, simply they have arrested means that time if the court comes to know, habeas corpus it will issue saying that release that person. So 2 things, one thing is produce the body, another thing is release that person if the arrest is not correct. Okay, that is the meaning of habeas corpus. Habeas corpus means produce the body within 24 hours. Clear? If in the exam, if it comes, you should be knowing this. Habeas corpus means produce that person. Like that you remember. Next is coming to mandamus. Mandamus means it is talking about to command. To command. To command means, see here, when you go to government offices, obviously you must all experience, you want some certificates or whatever, you have to wait a lot. You have to wait a lot or they will make you wait. Not just wait, they will make you wait. Okay, even if it can be done in 5 minutes, they will make you wait for 1 week, something like that. What they will do is, they are expecting something, bribe or something from you. At that time, with all the proofs and documents, you can approach the court. At that time, the court will issue mandamus, writ of mandamus. Writ of mandamus means to command, to ask that person to do his duty correctly. Okay, this can be issued against what? Public authority. For private authority, you cannot do. Mandamus can be issued against public authority, and what it says, the court will say what? The court will say, do your duty correctly. Do your duty correctly on time. Okay, they cannot delay your work. Suppose if it can be done in 1 week, it should be done in 1 week. They cannot make it wait for 1 month or 2 months. That is the meaning of what? Mandamus means to command. That means the court will command that person to do the work correctly. That is the meaning. See here, when the court finds that a particular office holder is not doing legal duty, then thereby is infringing on the right of an individual. That means legal duty means what? It is talking about public duty. If that person is not doing my duty on time or correctly, that time the court will say command. It will command that person do the duty correctly. That is the meaning of what? Mandamus. Clear? So habeas corpus is produce the body, mandamus is command. That is, it is telling do your duty correctly. Next thing is very important. See here, prohibition and certiorari. Prohibition and certiorari you will get confused. So prohibition means to forbid. To forbid. To forbid means it is to stop. To forbid means it is to stop. That is, it is issued by a higher court or a high court or supreme court when a lower court are considered case going beyond its jurisdiction. See, one thing you understand, jurisdiction means that is the operating area. Operating area. Suppose this is a police station is there in Narayanguda, you think. The jurisdiction of the police station, that is operating area, is only up to Narayanguda. It is only up to Narayanguda. Similarly, Himayat Nagar police station is there. That jurisdiction is only Himayat Nagar. That is the meaning of jurisdiction. Jurisdiction means what? It is nothing but operating area. Similarly, courts also have their operating area. They have their jurisdiction. Beyond that, they cannot make laws, or beyond that, not make laws. Beyond that, they cannot pass judgments. Suppose as higher court. Higher court means it can be Supreme Court or High Court. If they find that some court is taking up a case which is beyond its power, that time the Supreme Court or High Court. Suppose here there is a smaller court, small court. It is jurisdiction is this much, but it is moving away and making the laws or passing the judgment up to this much. That time Supreme Court or High Court will issue a writ of what? Prohibition, saying that stop the case, send it to us. Stop it immediately, send it to us. Okay, stop it immediately. Prohibit means what? Prohibition, that is to forbid or to stop. Stop it immediately, send the case. You don't have the power to make judgment on that case. That is the meaning of prohibition. The word itself says stop the case immediately. You don't have the power to make judgment on that, send it to us. That is the meaning of prohibition. When I told jurisdiction, you have to understand one thing. Certain times, okay, certain unforeseen circumstances are there. Okay, suppose you are a person from Narayanguda and some crime has happened to you, but you try to escape, and Narayanguda the crime has happened against you, but you go to Himayat Nagar. There you try to file a complaint. Earlier it was not possible to file a complaint there. You have to file it in your jurisdiction only. Now you can file a complaint there also. That is called zero FIR. That is called what? Zero FIR. Remember it. Okay. Apart from your jurisdiction of the occurrence of the crime, if you try to file a complaint in another area, another jurisdiction, definitely they can file a complaint under what it is called zero FIR. Okay, you have to remember this, zero FIR. Okay, if they give a question, zero FIR, because this is in current affairs lot of the time. Okay, that is the meaning of what? Zero FIR. Zero FIR. Since I am talking about jurisdiction, I am telling about this. That is the meaning of zero FIR. Clear? Now, I was talking about prohibition. So, if the jurisdiction is beyond that court, if it is trying to make a judgment, that time what will do? Supreme Court and High Court will say, please stop it, send the case to us. That is the meaning of prohibition. Now, what do you mean by certiorari? The court orders a lower court or another authority to transfer a matter pending before it to the higher authority or court. Okay, here certiorari means to be informed or to be certified. So, what it says is certiorari. Certiorari has the power to do what? It has the power to stop the judgment. Already passed judgment also, it can quash that judgment. Okay, suppose a lower court has already passed the judgment. Prohibition is it will only transfer, but when it comes to certiorari, already a judgment is passed by a lower court, but it is beyond its jurisdiction. That time that judgment can be completely squashed by the higher court. Okay, here in prohibition, understand the meaning. Still the case is going on, judgment is still not passed, but the powers are beyond its jurisdiction. That time what it can do? It can ask the lower court to send it to it. Okay, that is the meaning, case going on, that is case going beyond its jurisdiction. Still case is going on, but judgment is still not passed. But the higher court, that is High Court or Supreme Court, comes to know he is conducting a case which is beyond its power. That time High Court or Supreme Court will say, for example, District Court or something, it will say that please stop the case, send it to us. Certiorari means already judgment is passed, you think. It may be going on or already passed. That time that judgment will be completely squashed or completely taken out, and again that case will be taken by the higher court, High Court or Supreme Court. Higher court means I am not talking about High Court. It can be High Court or Supreme Court. Again the case will be conducted. That is the meaning of certiorari. Understood? Prohibition means completely stop it there before the judgment is passed. Certiorari means even after the judgment is passed, you can take that case. It can completely absolve the judgment. It can completely remove the judgment and then it can take the case. That is the meaning of certiorari. Don't get confused. But both are related. Now coming to quo warranto. Quo warranto means by what authority? By what authority? Quo warranto means by what authority? By what authority? Quo warranto means by what authority? So what do you mean by what authority? So quo warranto means by what authority? See, suppose you people enter the institute. I will say you are not supposed to enter our institute. Okay, that time I am just a faculty here. Okay, that time you will question, who are you to stop us? That is the meaning of asking what? By what authority are you telling us not to enter? Okay, I am not empowered to stop you from entering the institute. Correct? No? Which I can, but still I am telling as an example. Okay, by what authority are you stopping us? That is the meaning of quo warranto. That is the meaning of quo warranto. Understood? Quo warranto means I am giving real life example so that you understand. You don't forget in the examination. Quo warranto means suppose you are not empowered to perform that duty, but still you are doing that duty. Okay, you should not do that duty. You are not having that power to do that duty. Your power is only this much, but still you are going up to here and doing the duty. That time the people can come and ask you, by what authority you are doing the duty? You are not supposed to do the duty, other person should do. That is the meaning of quo warranto. Okay, that time writ of quo warranto will be issued. Okay, so see here, quo warranto means if the court finds that the person is holding office, but it is not able to hold that office, it restricts the person from acting as an office holder. That is, I am going and sitting in the chairman's position. Okay, but I am not eligible. Example I am telling. That time court will say that you are not eligible to sit as a chairman. Okay, please quit the office. You don't have the authority. By what authority? That is the meaning of quo warranto. Okay, it is talking about the position of the person. Okay, so I will revise again. Habeas corpus is produce the body. Mandamus is to commend. Do your duty correctly. Mandamus. Prohibition is stop the case, send it to us. Certiorari means complete, squash the judgment and transfer to us. Next is quo warranto. By what authority you are holding that position? You have to be absolved from that position. Other person who is the actual eligible person will conduct the duty of yours. That is the meaning of quo warranto. Clear? So these are all the 5 writs you have to remember. Very important. That is under Article 32. This is about what? These are all the constitutional remedies. What are the constitutional remedies? These are 5 writs issued by what? Supreme Court and High Court. Supreme Court under Article 32. High Court under Article 226. Okay, 226. So right to constitutional remedies under Article 32 by Supreme Court, 226 by High Court. It issues remedies. Constitutional remedies is given by 5 writs. That is, writs means nothing but a written notice. 5 writs are what? Mandamus. First is habeas corpus, mandamus, prohibition, certiorari, and also quo warranto. Quo warranto. Got it? Next is now fundamental rights. I am discussing from the beginning itself. Fundamental rights are not absolute. They come with reasonable restrictions. Reasonable restrictions, I told you, it is public order, morality, health, security of the nation, unity and integrity of the nation. You have to remember this, and other fundamental rights. Okay. Now suspension during emergencies. So when there is emergency, especially national emergency, fundamental rights will be suspended. Suspension of fundamental rights during national emergency, which constitution? South African constitution. Correct? No, we borrowed from there. Which constitution? You just revise by yourself. Okay. Germany or South Africa? Revise by yourself. You put it in the comment section. I am asking a question, you put it in the comment section. Which constitution? I am not going to tell you. Okay. You just learn and put it in the comment section. So like this you have to revise the subject. Now when it comes to suspension of fundamental rights, all the fundamental rights can be suspended except 20 and 21. Even during any emergency, 21 should not be suspended. Remember, focus on the class. So 20 and 21 cannot be suspended under any circumstances. Article 20 and 21 cannot be suspended during national emergency. 20 means protection in conventions. Article 21 means right to life. Okay, that cannot be suspended. Understand this. Next is available only to citizens. But understand one thing, if national emergency is on the grounds of national emergency is on the grounds of external reason, that time Article 19 is also suspended. External reason, then Article 19 is also suspended. That means only 20 and 21 will be available to you. But if national emergency is due to internal reason, that time 20 and 21 will not be suspended. Along with 19 also is not suspended. Along with that, 19 is also not suspended. In general, during national emergency, all the fundamental rights will be suspended, but 20 and 21 cannot be suspended. But if national emergency, the reason for national emergency is external reason. For example, there was an attack by terrorists or by Pakistan, whatever you think. Okay, that is nothing but external reason. The external reason, that time you cannot, that time you can suspend Article 19. That time you can suspend Article 19. That means you cannot allow people to move there. Got it? Because you have to protect the people. That is Article 19 will also be suspended. But if it is due to internal reason, that time you cannot suspend Article 19. Understood? If national emergency is due to internal reason, in some part of the country, if there is national emergency, why do you want to stop people from moving in South India? Suppose national emergency does not mean it will apply only to entire India. National emergency can be applied to entire of India or to some parts of India. Okay, it will be applied to entire of India or only to certain parts of India. Understand one thing, national emergency can be applied to entire India or it can also be applied to certain parts of India. During COVID, that was one of our national emergency, but we didn't call it national emergency. That time also fundamental rights were suspended. That is the reason of health. That is article. Yeah, but that was due to health. That we didn't call it as national emergency. We called it as what? Pandemic. We called it as pandemic. We didn't call it as emergency. Okay, the government has to declare it as national emergency. We did not declare it as national emergency. So that is different. Okay, we never said that it is an emergency. We said emergency, but not national emergency. Not under, the government has to declare. That has to be passed by the parliament. Whether it's national emergency, you have to pass it by the parliament. Then only we call it as national emergency. We didn't pass it by the parliament. Directly we said that it is pandemic. Okay, so there you cannot say talk about Article 19, 20 or 21. 21 was only highest priority given because right to life, to save people's life, other fundamental rights were suspended. Okay, but it is not due to national emergency. It was due to pandemic. Okay, don't get confused. But in general, 20 and 21 will not be suspended. This much you remember. Very important. Okay, next thing is, I already told you, fundamental rights available only to citizens. That is, these fundamental rights 15, 16, 19, 20, 29 and 30. These fundamental rights are not available to foreigners. It is available only to citizens. Okay, available to all citizens and foreigners, everything. Okay, but these fundamental rights are not available to foreigners. That much you remember. Clear? Okay, that's all about constitutional remedies. Now, before going to the questions, I have to discuss about Article 33, 34 and 35. People ignore these articles, but actually they are also fundamental rights. Article 12 to 35, they are fundamental rights. We focus up to 12 to 32. Last three fundamental rights we forget. Okay, actually what is in the constitution, Article 33, 34, 35, I won't tell you exactly that way because you don't have to know it that way. You have to just know the meaning. Okay, so let us see what is Article 33. What is Article 34? What is Article 35? See, suppose people are in armed forces or special forces or paramilitary forces or police forces or intelligence agency. That time they cannot say that I have the freedom of speech and expression and leak the very sensitive information about our country to anyone else. They cannot say that I have freedom of speech and expression. That time, see, certain fundamental rights of these people, that is paramilitary forces, armed forces, are curtailed or abrogated. They don't enjoy the fundamental rights. First class itself I told you, they don't enjoy the fundamental rights just like us because they have certain responsibilities. Because of that, by virtue of that, they cannot enjoy certain fundamental rights. That is because of what? Because they have to ensure the security and unity and integrity of the nation. So, the parliament, what it does, Article 33, it empowers Parliament to abrogate. Abrogate means to curtail the fundamental rights of, not all fundamental rights, certain fundamental rights. To abrogate certain fundamental rights of whom? Armed forces, paramilitary forces, okay, police, intelligence agencies and other related agencies. Okay, Article 33, what it does? It gives power to the parliament to abrogate or to curtail fundamental rights of whom? Armed forces, special forces or paramilitary forces, also police agencies, intelligence agencies. Okay, all these people, certain fundamental rights. Okay, certain fundamental rights will be curtailed. By whom? By parliament. By why? Because Constitution itself is empowering them under Article 33. This Article 33 cannot be challenged in the court of law. That army people cannot go to Supreme Court and say they are not allowing us, Parliament is not allowing us, they cannot go. This Article 33 cannot be challenged in the court of law. Can't be challenged. Can't be challenged. Can't be challenged. Understood? This Article 33, that is, these paramilitary forces or these people cannot go to Supreme Court telling that my fundamental right is violated. If they say that please leave from the army, you can go home. That is what they will say. Definitely nobody, that is the integrity of our Indian army or whatever those agencies, they won't go. Agreeing to that only they have joined the forces. So Article 33 cannot be challenged, this you must know. Now what about 34? 34, before going to 34, I have to tell something called martial law. Martial law means in any place if there is military rule. If there is military rule, suppose in Manipur there was lot of violence. Okay, that time the military took over. Military took over. Okay, even now violence is there now. Okay, military took over. What they will do is they will make the rules. Okay, they will ensure that there is no violence, and instead of the normal administration or the MPs or MLAs making law, they will ensure that they will set the rules and regulation to ensure that there is no violence. That is the meaning of martial law. That is the meaning of what? Martial law. Okay, that is the meaning of martial law. Also, there is something called martial court or martial law or martial code or whatever. Under the martial law itself, okay, suppose a person does some mistake, suppose a person who is in the army or someone does some mistake against the country or whatever, that person will be punished under martial law itself. That martial law is different than the actual law we have. They won't take him to the court or something. Under the martial law itself, they will punish him. Okay, so Article 34 talks about restriction of fundamental rights, in areas where martial law is in operation. Okay, is in operation. Okay, restriction of fundamental rights in areas where martial law is operation. That is, where military rule is there, at that part you cannot say enjoy complete fundamental rights like other citizens like us. Okay, there certain fundamental rights will be restricted. That is, for example, right to movement. You cannot keep moving freely to any place you want. That place you will be allowed to move only if you need necessity. Otherwise, simply as and when you want, you cannot move, because you can also be what? Planning to what? Spread violence or spread hate. Okay, that's why restriction of fundamental rights in areas where martial law is in operation. One of the forms of martial law, it is nothing but it is called AFSPA. AFSPA is in active, for example, in Nagaland. Okay, because there are Naga rebels, or in places where there are Naxals, all these people. Okay, AFSPA means Armed Forces Special Powers Act. Armed Forces Special Power Act. That is also one of the type of martial law. Not exactly martial law, it is one of the form of martial law. So Article 33 empowers Parliament to abrogate fundamental rights of armed forces, police, all these things. Article 34 is talking about restriction of fundamental rights in which area? Where there is martial law. One of the types of martial law is AFSPA, and AFSPA means it is nothing but Armed Forces Special Powers Act. Okay. Next is Article 35. Article 35 says that when it comes to fundamental rights, or if you have to give power to or effect to any fundamental rights, only Parliament has the right to make the law, not any state. Okay, the state legislature does not have any power. When it comes to fundamental rights, only the Parliament can make laws, not the state government of Telangana, not the state government of Tamil Nadu, not the state government of Karnataka, anyone, or state government of Maharashtra, they cannot make laws. Only the Parliament of India can make laws. So, only Parliament can make laws to give effect to fundamental rights. Okay, only Parliament can make laws to give effect to fundamental rights. 33, Parliament has, it empowers the Parliament to what? To abrogate fundamental rights of armed forces, special forces, paramilitary forces, police agencies, other intelligence agencies. When it comes to 34, it is talking about restriction of fundamental rights where martial law is in operation. Next, 35, it says only Parliament can make laws with respect to fundamental rights. That's it. So that's all about fundamental rights. Very important chapter. Please revise it multiple times, because questions will be expected, not just expected, definitely questions will come. Okay, so now let us relook certain questions which you have left, and we will solve these questions and then wind up the class. Is it clear till here? All right. This question we already solved. Heart and soul of the Constitution, Article 32. Freedom to practice religion? 25th. Okay, 25th is practice religion, 26 is religious affairs, 27 is no taxation. Okay, 28 is freedom. There is no freedom from religious attending religious instruction. Remember like this, practice is 25, 6 is religious affairs, and 27 is tax, and 28 is instructions, religious instructions. Okay, next is double jeopardy is what? Double jeopardy is talking about 22. This we already discussed. Now article against arbitrary arrest and detention, 22. Okay, arrest is 22, conviction is 20. Conviction is 20, arrest is 22. Next is empowers the Supreme Court to issue writs, Article 32. This is High Court, don't get confused. Okay, Article 226 is talking about High Court. Both will issue writs, but so High Court is 226, Supreme Court is 32. Which fundamental rights is available to foreigners in India? Right to vote? Definitely they don't have right to vote. Right to life, that's it. Which fundamental rights cannot be suspended even during emergency? 20 and 21. Okay, 20 and 21. Got it. Now, which article deals with production of arrest? That is, arrest means 22. Arrest means arrest, that is 22. Conviction means 20. Okay. Cultural and educational rights are primarily meant for which group? Minorities. Very important. Primarily. If they ask in general, it is for everyone. Cultural and educational rights. But primarily means it is minorities. The right to property is now considered as legal right. Okay, legal right. Maneka Gandhi case. Okay, but when it comes to cultural education right, what was the case? TMI Pai case, TMI Pai Foundation case. Okay, versus State of Karnataka. The right to constitutional remedies enables what? Parliament to amend constitution. Enforcement of fundamental rights. Very important. It's not about amendment, it is talking about enforcement of fundamental rights. It is talking about what? Enforcement of fundamental rights through issuing writs, writs of habeas corpus, mandamus, quo warranto, certiorari, prohibition. Okay. Next is, which article prohibits discrimination in public employment? Employment is 16. 15 is discrimination. Okay. That's it. So, all right. We'll meet in the tomorrow session. I hope the session was useful. Please revise well. Okay. And in the next class, we'll be discussing about the part 4, that is directive principles of state policies, that is article 36 to 51. That is article 36 to 51. So, let's wind up now, and thank you so much. Take care.